In this video, we're going to be discussing some of the main requirements for becoming a permanent resident through a family petition while you are inside the United States. This process is called adjustment of status. And if you are outside of the United States and you have a family member who's a US citizen and you're using a family petition to enter the US, then that's a different process. That's called consular processing. So today we're just going to be discussing some main requirements for adjustment of status. The first requirement, if you are becoming a permanent resident through a US citizen family member, and this typically occurs in the context of a spouse, is the requirement of being inspected or paroled. So you either must have entered the US with a visa, or you must have been paroled into the United States. And that also includes being paroled in place while you're physically inside the US. So for example, there was a recent program announced by President Biden, which allows spouses of US citizens to apply for parole in place. And what that means is if you enter the United States unlawfully or without inspection, you can apply for parole in place to fix that unlawful entry, and now you basically have the functional equivalent of a legal entry or an inspected entry, which makes you eligible for permanent residence if you meet the other requirements. One thing that I check for in the context of inspection is when somebody says they entered through the Mexican border or even the Canadian border, I want to make sure that they were not inspected at all. Because if an immigration officer waved a car through the border and you happen to be sitting in that car, then there's a really good argument that you were inspected. And we would write a detailed statement to submit with your green card application to demonstrate that you're actually eligible for adjustment of status because you meet the inspection requirement. I have a couple of these cases pending. It's called the matter of Quanton Entry, and it happens through the Mexican border and the Canadian border. So typically we need to show you entered with a visa or you were paroled, but if you were waived through the border, even if you have no entry stamp, even if you were just 2 years old, we can also try to demonstrate that you were inspected and are eligible for permanent residence. Another thing that I check for when I'm trying to determine if you can apply for permanent residence through marriage to a US citizen or some sort of other family-based immigration petition is that you did not enter the US with a visa that prohibits adjustment of status. There are 3 examples that I can give right off the top of my head. The first one is a C1 crew member visa. If you entered the US with a C1 visa and you intended to work as a crew member, and that part is key. If you just entered with a C1 transit visa, you were transiting through the US, or you did not ever intend to work as a crew member, then this doesn't apply. But if you entered with a C1 visa and you wanted to be a crew member on board a ship, then you are not eligible to apply for adjustment of status in the US. I made a whole video specifically on this a few weeks ago. Go check that out. Another visa that prohibits adjustment of status is a J1 visa if your J1, which can be like an exchange student or au pair, a couple different contexts. If your J1 is subject to the 2-year residency requirement, then you're not eligible to adjust status after you overstay it. This will typically be listed on the bottom of your visa. It'll say like the bearer is not subject to the 2-year residency requirement, or sometimes it'll use the actual Immigration and Nationality Act code. But if you are subject to the 2-year residency requirement, then you must physically leave the United States for at least 2 years before you're eligible to adjust status. And there could be problems if you've already overstayed. So before you leave, you should talk to an immigration lawyer if you've overstayed your J1 visa, because there might be consequences that I'm not discussing in this video. The final context in which I've seen someone overstay a visa and not be eligible for adjustment of status is the rare occasion where someone enters the US with a K1 fiance visa and they don't marry the petitioner fiancés who brought them over to the United States. So the way this works is fiance visa requires a US citizen to petition for an immigrant fiance to enter the United States. If that immigrant fiance enters the US and says like, you know what, I don't want to marry this guy, but I'm going to overstay and just marry a different US citizen in the future, that's not going to work. You have to marry the US citizen petitioner who brought you over to the US, or look for a different option to become a permanent resident. You can't enter with a K-1 fiance visa, overstay, and then just marry a different US citizen and expect to adjust your status in the US. It might be possible to fix your status in the future, but it's not going to be through adjustment of status in the United States unless you entered some other way after you entered with the K-1. Another requirement to become a permanent resident in the United States after you've overstayed your visa, if you marry a US citizen or are applying for permanent residence through some other sort of family-based immigration category, is you must not have a prohibitive criminal history. So you can have some criminal history, but it depends on the specific conviction. If you were convicted, for example, in New York of misdemeanor DUI, driving under the influence of alcohol, you are not entirely prohibited from applying for adjustment of status. USCIS can still approve your green card application. And the reason for that is because the DUI statute in New York State does not have an intent element. You do not need to have intended to drink or be drunk. Someone could literally have just injected you in the neck with alcohol right before the cop pulled you over, and you are legally DUI. So the fact that there is no intent element has a lot to do with the classification for immigration purposes. But on the other hand, if you were convicted of a certain theft offense, even if it was just worth $1, you can very well be prohibited from applying for adjustment of status, because that is a specific classification under the Immigration Act that is prohibited, and you might need a crime waiver. So certain crimes make you ineligible for adjustment of status. A lot of times during an initial consultation, someone tells me like, hey, I was convicted of this, like disorderly conduct or DUI or like public urination or something. And I have to do a little bit of research in their state based on the statute that was written in their state to see if they are eligible for adjustment of status, or if this is going to create a problem that requires us to apply for a crime waiver. A lot of times, the US citizen spouse asks me like, hey, what about my criminal history? Because I've committed a lot of crimes. And my answer is, generally speaking, the US citizen's crimes don't matter, but there is an exception. And the exception is under the Adam Walsh Act. If you've been convicted of a crime, and it's usually a sex crime against a minor or something super serious like that, then you might be prohibited from petitioning for immigrant family members. And this will usually come up specifically in the context of sex crimes. And I think the idea behind it is you can't be trusted with that much power over someone. Being allowed to petition for somebody assumes that you're going to have a certain amount of control over them and power over them, and you've basically lost that privilege by being convicted of that crime. All right, guys, so those are 3 minimum requirements for applying for permanent residence after you've overstayed your visa, or if you're still on your visa in the US and you've married a US citizen, or are applying through an immediate relative family petition. If you have any questions, throw them in the comments below. I will answer them within 1 week of the video posting. After that week, find my latest video and ask your questions there, because I'll be putting all my attention on the latest video. If you're going through the family-based immigration process, you can always schedule a consultation directly with me. If you have any questions, we can create a plan on how to go through the process, or I can represent you from start to finish throughout the case. And ask us about our family immigration money-back guarantee. Basically, if you meet all of the requirements, then we have a money-back guarantee that says that you will become a permanent resident throughout this process, or your money back. There is some fine print. I'll go through the details with you. If you have any questions, call my office to ask them. And otherwise, I'll see you guys next week for another video.